So then, two developments. I've been telling y'all for a while now that the damages part of the trial is scheduled for the end of April. That's still on as of now. Those last 3 business days, I think it's the 26th, 27th, 28th of April. On Monday of this week, we had a pre-trial conference with Judge Stein and Ms. Simpson's attorney. One of the issues brought up was the town's motion requesting Judge Stein recuse himself from hearing the case. I'm not sure, I know 2 of you were on council when this really sort of took off back in 2019, but just to remind the 2 of you and bring you the others up to date, the issue originally was the, in the Simpson property, it's 305 commercial, I think. Is that right? How much?
Market.
Yeah, it's right off of 220. Intermittently flooded, past tense, throughout the years was been an ongoing issue. And the first part of 2018, I believe, the mayor at the time, Chuck Unruh, said to Ms. Simpson, we're going to fix this problem. Ultimately, the town allocated $20,000 to completely replace the line to Ms. Simpson's specifications. As she requested, everything done to her stated desires. So we got going on that process. We didn't hear from her for a while. We ultimately held a council meeting where we said if we don't hear from her, we're just going to go ahead and do it. Because we've got the money allocated, we'll fix the problem and everybody, in theory, will move on with their lives. We heard soon thereafter that she had hired an attorney from Norfolk who specializes in eminent domain and it's called inverse condemnation cases, that was coming and asserting that fixing the problem wasn't sufficient, that we needed to go above and beyond that and pay her an additional, I believe, $25,000, essentially for the hassle of being in her yard for a while we fix the problem. The town and then also threatened that if we did go to litigation, if we didn't agree to that, we would go to litigation, and that was going to be incredibly expensive because of his fees, frankly. So when we're faced with that, the town held a public hearing to discuss the issue of how we would how we wanted to respond to that. If the town wanted to say, okay, fine, we'll pay you the $45,000, or if we wanted to go to court and potentially litigate it. We advertised that as, it was, I think everyone at the time and currently knows, as the mayor just indicated with the donations, how tight the town's budget is, and that certainly was true then, as true as it is now. And we knew that there was no way that the town would be able to pay for that. It sort of barely scraped together the $20,000. Certainly wasn't going to be able to come up with an additional $25,000 or more. So we advertised the public hearing to discuss, and we advertised it as the possible imposition of the Jennifer Simpson tax. We named it, called it the Jennifer Simpson tax, because this is her decision. This is her choice to bring this attorney in. It's her choice to essentially force all of the citizens, attempts to force all of the citizens of Iron Gate to pay her for what she's chosen to do when the town, without raising taxes, without holding any public hearings, had already allocated the money to fix her property to her specifications. So that all came out, that was, I remember, it was Halloween, October 31st of 2019, I believe. The lights went off memorably. Not like this, like permanently for a while, like the town lost power. So that all sort of percolated through. They ended up suing because the ultimate decision at that public hearing was, we're not paying a dime more than the $20,000. We'll pay the $20,000 if she comes to her senses and lets us fix the problem. But if not, we're not paying her a dime more, and we'll go to court and fight it until it comes to a resolution one way or the other. So a couple years later, October of 2021, we end up having a trial. on liability, whether or not the town was responsible for the flooding, was responsible for her damages, which we've got, ultimately Judge Stein ruled against us. We have multiple grounds of appeal already based on stuff that took place at that hearing. But at the end of that hearing, Judge Stein says, and this, getting to this because this is ultimately the basis of the motion to recuse. So I'll just read what the statement, so you guys sort of have it to decide, because ultimately I'm going to ask tonight for you guys to sort of direct me to how to act one way or the other. So Judge Stein, at the end of this ruling, he's already said, finding the town liable for the damages, says that will be the court's ruling. I just need to say, we heard a lot here that's probably not really relevant. I don't want to go into all the back and forth about why things broke down and how things broke down, because I don't think it's relevant to the case. So he's saying this is irrelevant to the case. But I do need to tell you, having been involved in local government in one form or another for a number of years, having obviously been a citizen and a voter for a lot of years, that the town's conduct in placing this advertisement in the paper and referring to this as the Jennifer Simpson tax, and suggesting that if they had to raise taxes to solve a stormwater problem that the town has known about since 2011, that somehow that was going to be on her, the embarrassment and the shame that they put her through in doing that, quite frankly, the town is lucky that this case sounds in contract and not in tort, because if it was in tort, that advertisement alone would have supported punitive damages. Basically saying, the town's lucky I can't impose punitive damages, because if I could, I would. The town, he goes on, the town and everyone who was involved in that advertisement should be absolutely ashamed of themselves. And no matter what happens ultimately with regard to damages, I would hope the town would have the decency at some point to apologize to her for treating one of your town citizens in that manner. It's shameful. There's no excuse for it. No excuse has been offered today for it, and it was totally uncalled for. I forgot to mention at that hearing, it was in evidence that the town had offered and worked with her for about a year to fix this problem for her, had allocated the $20,000, had hired somebody, had the shovels ready, and yet he comes out and says that this was all somehow the town's fault, and that we should be absolutely ashamed of themselves. So, we get to the pretrial conference on Monday. I had filed this motion to recuse, basically saying this is beyond the pale in terms of obviously stating his personal bias against the town. If I could punish you, I would. I'm not sure how a judge can say, well, I can hear everything completely unbiased because I'm impartial, when I stated on the record I would punish you if I could. So we brought that up at the hearing on Monday. Judge Stein doesn't back away from any of it. Says his mentioning of the punitive damages was just sort of a callback to some other legal arguments about whether this was a contract action or a tort action. But he didn't say that I didn't mean that I wouldn't punish you. He just said the town's lucky, basically restated that I just said that the town's lucky that there weren't punitive damages available. And that he had sort of, I forgot the words, but he had sort of reviewed his conscience, and he felt that he was unbiased, could give us an impartial hearing, completely ignoring that the law is not only biased and impartial, but he also, in theory, needs to consider the public perception of this fairness in order that the public confidence in the integrity of the judiciary may be maintained. So it's not just what he thinks of himself internally, that he can be unbiased. He's supposed to be considering the fact that going on the record in public saying he would punish the town, that the town might say, that doesn't sound entirely fair to us, and might make the town question whether or not it's getting a fair trial, therefore whether or not this whole process is in any way legitimate. Ignores all of that and says that what he said, he didn't view what he said as any different from rebuking, his words, rebuking a party in a divorce case that is behaving poorly, or a criminal. So he's saying what the town is doing, and leaving aside for the fact that a judge shouldn't be rebuking a party in a divorce case in this manner, shouldn't be rebuking a criminal in this manner, much less comparing the town, who co-equal branch of government, making decisions for its citizens, that he feels it is his place and proper, again, this on the record, to rebuke the town basically in the middle of a trial, right after he's found us liable, right before he says, now we've got to set a damages hearing. So that's where we left that. I didn't say a whole lot because there's only so much you can say. I said what I feel like I needed to say for the town's behalf in the motion. It was clear where he was coming down, and I think he only helped our case by what he said. This was all transcribed too. Only helped our potential appeal by what he said on Monday. It was basically, yeah, I said all that and I meant it, but trust me, I'm unbiased. So that's where that stands. Question for y'all on that issue tonight is, there's a couple ways we can potentially address this. One, this is, I think, clear grounds for appeal. Both the original statements, the law is it's ultimately up to the judge to decide whether or not the judge feels like they should recuse themselves. So that's the law, is that it's his decision ultimately until it gets reviewed on appeal. So we've already got multiple grounds on appeal based on the statements that he said that he's clearly biased. Now we have an appeal on the motion to recuse. So we've got another one that we can appeal that decision on the motion to recuse. So we could let this issue lay and go through the damages hearing at the end of April with Judge Stein down here with the jury, viewing the property, going back up to Covington, hearing the evidence, ruling on the evidence, what comes in, what doesn't come in, and go through that process. At some point get a final order and then appeal. Or we can now file a motion to reconsider, which is exactly what it sounds like, is if a judge makes a decision that you don't agree with, you have the right to file a motion to reconsider, and that basically asks the judge to reconsider his decision. At this point, the town, other than what I've put in, the town hasn't responded officially in any way. So my thoughts, my sort of point for discussion is to inquire whether or not the town council would like to draft a resolution stating the town's view of this is, I don't want to put words in your mouth, but this is clearly raises questions at the very least about whether or not the town is getting a fair trial. And of course, I'm happy to draft that. We can talk about sort of the language, what we would want that to say. But have that be an affirmative vote of council. So it's not just sort of me as your attorney saying, hey, I think this is wrong. This is the town itself saying, hey, we think this is wrong, officially as a body. Attach that resolution to the motion to reconsider and say, Judge Stein, we heard you on Monday, understand what your position is, but here's how we see things, and see if that moves the dial at all. Frankly, and I'll be 100% honest with you, I don't think he will change anything. But at least then we will be on the record, so then when we do end up appealing, we can say to ultimately the Supreme Court, the town as an entity clearly made this known that the town perceived this as unfair and has questions about whether or not they are getting a fair trial throughout this process. So if that's the route you guys would like to go, my thought is we can talk about the language. I will draft something up. Essentially have a work session so we don't have to do a whole new meeting for this. Turn the work session into a special meeting so you guys can vote on this. Have the vote at the special meeting and then file the motion to reconsider after whatever date the work session would be, and then go from there.
All right, when is this set to go to court, or set to go to trial?
End of April.
In
April 26th.
April 26th, okay.
Is that the Wednesday?
That would be Wednesday, yes, last Wednesday of the month. And our work session would actually be April 17th, the Monday before, week and 2 days.
Jared, I just have a couple questions.
Sure.
Not here then. The $20,000 that we initially, nothing was done, in other words.
Right.
It was all set up, but no action was taken.
Correct.
Is the water problem corrected?
Yes, the town's basis on daily visits or drive-bys of the property, even during extremely heavy rain events, is that the property has not flooded since any of this took place.
Does she reside at the property?
I believe she has renters. I think they're family members in some way connected, but she no longer actually lives in the property. But she does have, still owns the property, still has people there.
And so the additional amount she's asking for total is $45,000, is that correct?
That was before.
That was then?
Yeah.
It's gone up, or you suspect it will go up?
Well, that will bring the next point of, we finally yesterday got their claim of damages for the case. And we'll go into this after we'll go into this in more detail after we talk about the recusal. Their total claim for damages, all told for her individually, is roughly $37,000. That doesn't include fixing the problem. That is the town leaving it as it is, flooding it every now and then. We give her $37,000.
That's for her stress and all that?
Well, it's for some personal property, actually sort of taking the land when it's actually flooded. And then the biggest chunk of it, $30,000, is the diminution of value of the house. If she sells it, she's got to tell people it floods. We'll talk about that. So that's where that number comes from. The kicker is this law firm that she hired from Norfolk back in October, November of last year, so 6 months ago, multiple filings ago, claimed that they should be reimbursed by the town to the tune of $148,000. So once we get to the trial, they certainly, I would think, realistically are going to be looking at claiming we ultimately owe them $200,000. And that the issue back to the recusal is the person who decides if we have to pay that money and how much money is reasonable would be Judge Stein.
And when he made those initial remarks, was there a jury present?
No.
But there will be.
There's a jury for the damages.
Because if that's his attitude and he speaks that way, he biases the jury.
Yeah.
And so we have appealed because he decided not to recuse himself.
Well, we will appeal.
We will.
But we don't have the right to appeal until we go through the rest of this process.
I see. But he can again say no.
Yeah.
That doesn't seem right.
So, does anybody else have any more questions for Jared?
In regards to our former mayor, since he was the point person throughout this issue, will he have to come back and testify?
He's going to come back to testify at the damages. He testified as much as we needed him to at the liability.
Yeah.
So he doesn't have a whole lot to say at the damages, other than she never presented the town with a claim for actual damages.
Because most of us up here have, would only be hearsay, is what we've been told, so.
Yeah, no, he's going to be available for whatever we need him to do. But that sort of leads to the next issue of what they're actually claiming for damages is, in theory, we've sort of been acting under the assumption that what was driving Ms. Simpson was that the town wasn't paying for like the personal property. That's what she keeps, I burned up 2 sump pumps trying to get rid of all this. I've got fence posts that are now damaged and warped. As part of what they turned over yesterday, the appraiser that they've got valuing all this values her personal property damages at $2,100. So I don't want to speak for the town, but I feel, being there at the time, if, when all this was taking place, and we had allocated the 20,000, we had the shovels ready to go, if she had come in and said, appreciate that 20,000, looking forward to getting it fixed, by the way, I've got $2,100 in damages, I feel pretty confident town council at the time would have said, we'll figure that out. It's not in the budget, but we'll figure that out and we'll take care of it. But she never did that. She went and hired this lawyer instead. So the other part of their, I think that's the clearest. And another thing I'm gonna ask for y'all's vote tonight is for me to offer, it feels like a big part of their planned case at the end of April is for Ms. Simpson to testify about her personal property damages. They list a bunch of fence posts and boards warped and all this other kind of stuff. Instead of having her go through a morning going through all of this line by line in theory, just saying, look, we think 2,100 honestly is a little high, but we'll agree that your personal property damages in this case were $2,100. And just, hopefully, I doubt they'll agree to that, but I think we should say, you know what, we're willing to stipulate $2,100 in personal property, and let's move on to the next issue yet.